What do we always do?
What do we always do? We do IP in the news.
That's right. That's the correct answer to the question. So what is on the table tonight?
Well, so we're going to take two different sides on this, I think. So I'm going to take the
So we're
techie
going to be
side.
adversaries.
Yes.
Okay.
We're going to do Oracle
As a
versus
lawyer, I love this, but let's go.
Oracle versus Google.
Mm-hmm.
I'm going to take the tech perspective. Richard's going to take the IP attorney perspective.
Okay.
And so there's this article in Ars Technica. This explains the tech perspective in a nutshell.
You're wrong. I can just tell it right off the bat.
How the Supreme Court saved the software industry from API copyrights.
I'm sure we all want to hear about this.
And so basically, they told Oracle, who invented the software that everybody uses for APIs all over their websites and all their programming and everything.
But what is an API?
It is.
You
it
like a type
it.
of vegetable or something?
You explained it really well. It stands for Application Programming Interface, but Richard has a really good way to.
Right. So if you wanted to hook two computer programs together, you use an API. So if you have an accounting software like QuickBooks and you want to connect it to your website, there's an API that connects the two programs together. And so this was what the subject of this suit was.
And so years ago, Oracle invented that software and then let everybody use it. And then they tried to reach back and grab it back and say, you're making money from it, so you have to pay us for the copyright on it. So they used copyright law to do that. And Google, who had been using it, was like, no, we're not going to pay you. And there's fair use doctrine, all these different arguments they used. And so everybody uses these. So as soon as the suit was settled, or right before the suit was settled, what did Google do? They started charging everybody for their Maps API that used to be free. And I'm like, wait a minute, you took it from Oracle.
I know you hate this part. She's
so
been talking about this
this
all week ever since the
well,
case
yeah, because
was decided.
I lost the Maps API on my website for Fireside and have to pay for it now.
But the interesting thing is that you can copyright computer software. You can also patent it. So this was a copyright case, not a patent case. So there are two different types of intellectual property. And so it's important to keep that straight. You can still patent software. The question was, were these little programs that they put together to create these interfaces, were they protectable under copyright law? And the Supreme Court said, no, you can't, they're not copyrightable. And I think the reason they did that is because they want the tech community to flourish. This is a tool that developers use to improve the quality of the software. And I think undermining all of this, or the underpinning here, was that they didn't want to slow down technology. And so I think the Supreme Court actually made the right decision here. There's still other types of protection available for other types of computer software. And I think it's also made the lives of computer programmers a lot easier, because now this is one less thing that they have to worry about.
Right. So everybody uses it. So they all use the same thing. So different devices and different programs can talk to each other. And so if it had gone the other way, then you'd have people programming their own different APIs and nothing would be standardized anymore, and it would just be a mess.
Right. So a decision of significance by the Supreme Court in the world of intellectual property, and let's keep the technology moving forward.
So Patent Palooza.
So you found this one, or did I find this one?
No, I found this one.
You did find this one. Okay.
So for our viewers on YouTube, well, this will be cut into. So this man I love this invention, but
I think it's ridiculous.
It comes up when you Google crazy. It's called leaf gathering trousers. So what you do is you pull on these tubes over your pant legs, and in between the tubes is netting, and then you rock and gather leaves.
I guess I just wouldn't want to use it, because I'd be concerned my neighbors would think my pants are full or something like that, waddling across my lawn, with this kind of weird.
I thought it was a fantastic idea. I would have loved to have these with our kids. Oh my gosh, I could just imagine.
Yeah, our son would have just done a barrel roll and knocked us over. So
I don't know if he ever commercialized it, but too bad if he didn't. So
right. So that's a wacky patent, and we haven't seen it on the market yet.
It would be so much fun.
Okay. Well, we'll make you a pair for Mother's Day. How does that sound? So that said, it's time for Richard's Roundtable, and we get to ask our guests what they think about these stories, these important IP stories, or ask any other questions that they may have about intellectual property. So let's start with Jeff. Jeff.
Well, something occurred to me, Richard, in your field. They may have a patent, but they need a brand name that should have a mark. How about Leaves Come to Me? That seems to me to be fun. But they should hurry up and apply for the mark before somebody else gets it.
All right. Well, now it's out there in public, you know. That's a great comment. So, Pamela, what are your thoughts?
So I actually was thinking about the Google Oracle situation. And I think, Richard, I'd love to hear your advice around what that was like a collaborative effort, and what are the best practices to avoid the downstream effects of not discussing your collaboration and agreement up front. Because I run into that regularly. I've got 3 collaborations going right now, and I'm eager for some advice over, everything looks happy and rosy up front, right? When you're starting the planning, everyone's excited. And then all of a sudden you get to the reality of the business engagements related to that collaboration, or if it doesn't work out, the ownership of it. So I'm eager to hear your thoughts.
Well, sure. So that's one of the uses of attorneys, is to be the bad people and discuss what happens if things don't work out. And then you get it in the contract. And so it's clear. And so usually clarity is the best policy. And sometimes the parties, when they're getting a business together, they don't know all of the things that are going to happen in the future. And it's hard to anticipate places where there might be disagreements. And it's unpleasant to talk about downer things. Who wants to buzzkill their new business, right? But the lawyers can play a role in talking about, based on their experience, where they've seen things go wrong, and put some safeguards in for the clients. And then the lawyers can kind of duke it out, and it doesn't really hurt the client to client relationship. And so that's really my best advice, is to, think about your project with as much clarity as you can, and define what you're going to do and who's going to do what. And then, at the end of the day, get a good contract and good attorney to help you out to sort all those things out.
Thanks. That's really great.
Yeah. So Kenya, what do you have to say?
No, I really like that point that you just made about just having those conversations up front. And my question for Richard is like, how soon should you start having those collaboration conversations, and what level of transparency should you be at when you first initiate those types of collaborations?
So my advice is always start with an NDA. So you want to make sure that there's an awareness on both sides that what you're talking about is to be kept confidential between the parties. And then usually it starts with a term sheet, which is just a piece of paper with bullet points on it where you have points of agreement. So if it's going to have a selling price of X and you're going to produce so many units of Y, then you need to get a rough structure of what the project is going to look like, who's going to contribute what, who's going to do what. I'm going to be the software developer, you're going to be the marketer, and you want to get some clarity around the roles of each person or each company. And then once you have agreement on that, you can turn it over to the lawyers, and they'll usually have a template contract that they've used in the past, and they'll modify it for that particular collaboration. And then usually you always want to, anytime you sign any kind of contract of any substance, you want to have an attorney at least review it. And because I've seen so many times where people have tried to do it themselves, and if you're spending any money at all on the project or making any investment, it's worth it to have a lawyer look at it. So I can tell you horror stories, but
So anyway, have time. That was too long anyway.
That was too long. So when somebody asked me a question about law,
okay,
I can't
Lisa,
shut up.
Yeah, so. Lisa, don't ask a question about law. No, I'm just kidding.
So I have a question as a small business owner. As a small business owner, when you have employees and you develop a product, let's just say it was a software, an application, and you apply for a patent and a trademark, does it belong to the company, or does the employee own rights to that? How is that handled? That
is an interesting question. So the answer to it comes at Preferably, when you retain the employee, you have some sort of contract that requires them to assign the project over to the company so that they own it. And if you don't have that contract, a whole schedule of rules come into play that the employee may have ownership rights in the invention, depending on what it is and when it was constructed. If it, was done in the course of their employment, you might have a better case of getting a court to assign it to them. But then it's really comes down at the point of hire. You want to make sure that they have an obligation to assign it to you. And then if they don't, and they refuse to assign it to you, then you have to get attorneys involved to figure out, what is the best way forward.
But as far as a patent would go, if you had employees that were collaborating that invented the patent together, all their names have to be on the patent as inventors. But then they typically assign it to the company.
Right.
So, and then once they assign it to the company owns it and they don't get any more rights in it at all.
Right.
Okay. Thank you.
Yeah.
Sure.
So Chris.
Yeah. Well, there's been a lot of intelligent questions. I'll ask the opposite. I have to question about these pants. I have a question about these pants here.
Oh, okay.
Yeah, leaf gathering browsers. So for these pants, you always see wacky patents like this. I guess it's a good thing that they charge for patent applications. Otherwise, people will be trying to patent everything. But I do have, I think, a somewhat serious question here. When you have a patent like that, is there ever a little bit of that person's mind thinking like, if somebody comes out with something similar, I'm first, even if it is a legitimate thing that people might buy? Like, I know, rollerblades are the one that everyone likes to bring up. But if somebody in the 30s said, well, I guess that might be too long ago, but within the right statute of limitations said, I'm going to strap a bike tire to my shoes. And then 3 years later, the guy tries to patent the rollerblades. Was it all intentional to have like some wacky patent because I'm going to protect it in some way later and make some money off of this? Or is it just some clown, doing fun stuff for something to put on his wall at home?
Both. That's a really good question. Some people that we've encountered do get patents just to get a patent because very few people actually own patents. So if you do own a patent, you're in a very, elite.
You're in a rarefied club.
So, but they really do intend to make things a lot of the times, I think. And I think where people run into trouble is in their marketing. So I've seen wonderful products flame out and die because they don't put the money into the marketing. And so I think the answer is yes in both cases.
Right. And I mean, there are just so you know, I mean, there are people who want to file patents just to say they have a patent. So they're called vanity patents. Lots of times companies file a lot of patents, like a lot of technical companies, because the scientists and the inventors get another notch on their resume every time a patent is filed. It's an indication from the patent office that your idea is new and you're the first one to think of it. So a lot of people take intellectual pride in filing patents, even if it never turns out to amount to anything. So anyway, to answer your question, yeah, that is the case.
Okay. Well, thank you, everybody. Those were great questions. Chris, thanks for ending on a fun note.
Well, if you've got something wacky, let us know. I once had a salesman say, "Can I patent this martini?" And I was like, "Sure." And it cost you $5,000. Well, I'm not so sure about that.
But